All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We are here today in our case number CV180709, Arizona Biltmore Hotel via Condominiums Association versus the Conlon Group, Arizona, et al. Counsel, we now are leaving instructions on the table for you so we can begin sooner. And with that, Counsel, you may start.
Good morning, Your Honors. My name is Mark Lyons. I represent defendant and appellant Mark Finney in this matter. Your Honors, the history between the parties is extensive as far as their dealings, prior litigation that they were involved in, and those issues are set forth in the briefs. And rather than rehashing those facts, I believe it'd be more pertinent to address those issues and errors of law that warrant setting aside the judgment entered against my client, Mark Finney. With respect to those issues, I believe that the first issue and most obvious error of law is the calculation of damages employed by the trial court in rendering a judgment against Mr. Finney. The damages were calculated with specificity as to the dollar amounts. However, they included specific amounts that were directly and expressly precluded as claims against Mr. Finney. And that in and of itself to both expressly deny claims with respect to certain damages. And
Are you talking, Counsel, about the northern-southern distinction?
Correct, Your Honor. The northern part, in the 2013 lawsuit and litigation, there were two issues involved, or two claims involved. One was with respect to the control of the northern parking spaces in which all of the villa owners had an interest. And then there was the control of the southern spaces that the association superficially or on the face of it had the interest in with respect, and also Mr. Finney had the assignment interest in those parking spaces. The trial court held that there was no claim or cause of action against Mr. Finney with respect to the northern parking spaces damages claim.
So Counsel, let me ask you a question. Let's say I agree with you, we agree with you. Is there evidence in the record from which the court could make that decision and separate the northern fees from the southern fees? Or would we have to order the court, hold an evidentiary hearing or additional discovery? Is that evidence in the record and the court simply ruled a certain way and didn't account for it? Or is that evidence not in the record?
Your Honor, it is not in the record. It's referenced in my client's opening brief where evidence was offered with respect to all of the legal invoices which comprise their damage claim. And
so those are in evidence?
They were offered, but they were not actually admitted into evidence, Your Honor. The only evidence that was admitted into, for purposes of looking at damages was a summary offered by plaintiff's counsel of the total damages, which conflicts with the summary and tallying of the damages that were calculated by the plaintiff's expert witness. The numbers differ, but the trial court accepted the expert's tally of those total damages, and the expert confirmed repeatedly that it was simply a total amount of all of the legal fees and costs incurred from 2013 forward, with no differentiation or distinction between what was incurred with respect to the northern parking spaces claim or the southern parking spaces claim. The trial court, in fact, saw this issue at the time of closing and queried of counsel whether or not there was anything offered to distinguish the amounts incurred with respect to the northern spaces and the southern spaces. In closing argument, the counsel confirmed, no, Your Honor, we have not offered anything to distinguish that. The only thing that was admitted into evidence was the tallies or the summaries of those calculations. Again, those total amount, the total invoices or all of the invoices were at one point offered, but they were not admitted into evidence.
Did you move to reconsider on that basis?
No, Your Honor.
Or a
we didn't.
new trial, or on this damage point?
I cannot remember standing here whether or not we've moved for a new trial. I believe we did. But I would need to take a look at that.
Okay. That's all right. Go ahead.
Your Honor, as far as those damage calculations, to expressly deny claims, but then to include $1,049,000 as the basis of your calculation, which includes all of the legal fees incurred in both the northern parking space claim and the southern parking space claim, is just simply an error of law to deny claims and then to actually award damages based on a calculation that includes those damages in that
So
claim.
again, assuming that we agree with you, which I'm not saying we do, but just assume that, what is the remedy and how do we correct this error?
Well, Your Honor, I believe that the judgment needs to be vacated at the very least, and then if I believe that it would need to be remanded to the trial court for a new trial on the issue of damages, whether or not it's based on the evidence currently admitted without admitting any additional evidence, or to start over with the evidence. I'm not sure exactly which the correct remedy would be, but
You're saying that we'd also have to toss liability?
I believe that
And why is that?
the liability, Your Honor, is premised on the idea of causation as an essential element of the damage claims, and without proof of causation as to which damages were caused or attributable to a northern parking space claim or the actions of my client with respect to the southern parking spaces claim, there's no causation to calculate and to determine an amount of damages with reasonable certainty.
Damages.
Correct, Your Honor.
Right. I mean, the points on liability and the safe harbor, I mean, I understand that you have arguments to those, but those remain intact under this argument of yours, if accepted.
I'm not sure if I understand what you mean by remaining
Sure,
intact.
sure. The significance of your argument that that northern fees were added when they shouldn't have been added
Right.
doesn't have an impact on the court's safe harbor interpretation or other issues. It is limited solely to the amount of fees that are recovered as damages.
Correct, Your Honor. The argument that damages itself and the way that they were calculated it presumes that the issue about liability under the safe harbor statute is accepted, that the trial court's findings are accepted. We don't waive, of course, the argument that the liability should not attach because of the safe harbor statute and the application of the statute.
Let me ask you a factual question, which is I think it was 1995, SRP entered into the, probably not dueling joint use agreements, but these two joint use agreements, one with the hotel and one with the association. Were those authorizing the use of separate lots? So was the hotel authorizing was SRP authorizing the hotel to use the northern lot and the association to use the southern lot?
I can't speak exactly as to what those joint use agreements actually say, and I don't have any personal recollection of what they authorize. My understanding simply is that there was a joint use agreement that was entered, and there were parking spaces that were allocated for the use of the villa's owners and the hotel itself. Which ones were allocated as to which, we'd have to look at the joint use agreement itself, which is entered into evidence. But standing here, and I apologize, Your Honor, I don't specifically recall myself as to what those allocated.
Right. Okay.
With respect to the safe harbor statute, I would submit that the trial court incorrectly interpreted that statute in holding that there was a failure to disclose under that statute, and therefore the immunity that's provided under the statute did not apply to the 2013 lawsuit. In finding that adequate disclosure was made in 2011 with respect to the subject matter of the transaction, that being attempt to control the southern parking spaces for purposes of the revenue potential, and the actual conflict of interest that Mr. Finney had with respect to that met the disclosure requirements under the statute. The trial court then distinguished the 2013 lawsuit, claiming that it was a separate transaction or a different transaction, and that there was different disclosure required and that there was no disclosure. That doesn't make sense with respect to the express statutory language that says that disclosure at any time of the subject matter of the transaction and the nature of the conflict of interest, to say that that was unknown is simply a fiction.
Counsel, doesn't the statute use the words required disclosures?
Correct.
And that's a defined term.
It is.
And it includes all facts known to the director respecting the subject matter of the transaction that an ordinarily prudent person would reasonably believe to be material to a judgment about whether or not to proceed with the transaction. Is that how it's defined?
Yes, Your Honor.
So that's more than just the conflict and the existence of the relationship.
That's more than just, here's my title in this organization, now in perpetuity I can do whatever I want.
No, I agree, Your Honor. At the same time, the trial court found that the failure to disclose related to the risks involved in the litigation and the potential costs involved in the litigation. And I would submit that neither one of those are something that my client can state as a matter of fact, and that's what the statute
But he had
requires.
received a letter from the attorneys and didn't provide that letter. So regardless of whether it was stated as a fact or not, he at a minimum didn't provide the information that the attorneys had provided to him.
Your Honor, the evidence does not say that he did not provide it. It's the trial court, I believe, did not find that the claim that he provided it was credible. And if I'm mistaking that or as being different than what Your Honor has described it as, my client testified that he did copy it and send it to the management company to forward on to the board of directors. The board members testified that they didn't receive it. That's a disputed issue. That was a disputed issue in that. But assuming that that was the case, the disclosure that the trial court found that he failed to make was that the northern parking space claim was stronger than the southern parking space claim, in which he had a direct interest in the southern parking spaces. It's ironic or interesting that of the two claims, the northern parking space claim was the one that was dismissed flat out, whereas the southern parking space claim was the one that they recovered hundreds of thousands of dollars on. So the fact that litigation counsel had advised that it may have been a weaker case was not even a fact in reality and in the outcome of it, where it actually ended up being the stronger of the two cases as far as the monetary recovery is concerned. And so how he can fail to disclose a fact that has not come to fruition, I don't see that as being violative of the statute or short of what is required under the statute.
What's our standard review on these things? Because it sounds like there's some things are factual, whether he did or didn't disclose it. And
Well,
that would be a very differential standard review to the fact finder below.
My
And then there's
understanding,
other things which are possibly the weight of the import of the disclosures. Are those the same standard of review?
Your Honor, my understanding of this court standard would be that when we're talking about an application of statutory terms or interpretation of statute, that both facts applicable to the statutory interpretation and the interpretation of the statute itself are reviewed de novo. And so
I don't follow that breakdown. So what do you mean the facts applicable to that statutory interpretation?
well, with respect to,
I mean, so if the trial court found that he did not make the disclosure, I'm not saying that's what they found, but let's say the trial court found that specifically, and therefore this trial court interpreted him as not meeting the statutory requirements. We would review that de novo? Is that your argument?
my understanding is that the facts applicable to the statutory interpretation would be reviewed de novo. If I'm incorrect on that, then that's my misunderstanding of the law, but that's what I can offer, Your Honor. We're running short on time with respect to also providing time for co-counsel to argue, and so I would like to reserve that time for co-counsel.
My name is Dan Finney. I'm representing the Conlon group. I want to get one point clear if I could. My understanding is that each side has 20 minutes. We're splitting as close as we can, 10 and 10. So I would like to save some at the end. And I see we have a timer here. So
It's up to you to save that, but that's perfectly fine with
So
us.
is this 546 what's left of our
Yeah,
side?
just stop it for a second. Correct.
Okay, all right, well, I'll be talking fast then.
Okay.
We'll try not to interrupt you.
All right, I have prepared a brief for you people about the Conlon Group's contract and why I think this case should be reversed outright. Everything in that brief, everything cited is directly from the court's own findings of fact and conclusions of law. I'm not here to argue with you about whether one fact is more credible or not. First of all, it's not the standard, but secondly, I didn't. The issue here is the contract says quite clearly, and it's an exhibit, that all revenue or value which the Conlon Group may derive from the parking spaces shall belong solely to the Conlon Group. And it then says the association agrees that it shall vigorously pursue the lawsuit, including any and all necessary appeals, to a final conclusion as needed to obtain control of such parking spaces, all at the association's sole cost and expense. Now, I've listed in my brief the other findings the court made with respect to how well that was vetted by the board of directors without Mark Finney's participation. They had their own attorney. One of the board of directors had another attorney look at it. The board's attorney advised them, a guy named Mr. Tully. He also advised them to get their own attorney. The contract, which they then signed themselves, specifically says, we've vetted this. We agree we've vetted this. We agree we've talked to attorneys, and there's nothing in here that we don't understand. Now, the significance of that is this. The trial court then turns around and bases most its argument for both liability and damages that the Conlon Group failed to tell the board of these two provisions that are in the contract.
Of
The provision that the litigation had to be conducted.
Well, I think the first thing the court said was that there was a letter from Scheifetz that assessed the merits of the proposed or actual litigation, and that wasn't forwarded. So I think that's more likelihood of success, cost of a litigation rather than a...
I'm going to address that in just a moment, Your Honor. I want to get through with this first part simply because the court actually said that they found him responsible, and I'm going to quote, most importantly, by not clearly disclosing to the association Finney's belief that the association had to litigate at its own expense the claim against SRP solely to vindicate Finney's claim on the southern parking spaces. So if we were to take the court at its word, that was the most important finding the court had for finding Finney and the Conlon Group liable. But then we have the problem that everybody the court has made findings that everybody knew what the contract was about, and they were sophisticated men.
Where do you get that, the most important?
I've read it. This is right from the order, Judge.
No, yeah, but your most important, because remember, I just raised another point that the court was concerned about. That wasn't about the undisclosed, I guess, pot of gold at the end of the rainbow, and that he didn't tell them, you got to litigate this and you got to do it for me. That he left out the second part. What about the first part, which is just not sharing?
All right. The first, I will answer that, Your Honor, but first I'd like to point out, how do you separate the court's finding? The most important thing for the court is clearly not true because of what the clear language of the contract is. How do you separate that from everything else that was decided by the court? I suggest that's impossible, but getting back to...
But that was a prior litigation, wasn't it? That was the 2010 litigation.
The court also found that the contract, there was one contract, it was from 2011, 2015, and all parties operated as if they understood the contract to be
But
one.
it was one contract, but it referenced the 2010 litigation only discussed the 2010 litigation. This is now 2013 litigation.
Your Honor, all I can tell you is what the court found. The court, and I'm using exact language. He said it's one contract from 2011 to 2015.
Which is why he let you off the hook on the 2010 litigation, but not on the 2013 litigation.
Well, I only have a minute, so let me address if you don't mind, the point that Judge brought up. The court made a finding that, and this is another problem, made a finding that if the board had known about this letter, in which case it was described one case being stronger than the other, then they wouldn't have let the litigation to spiral out of control. But the board, a year and a half before the litigation ended, there was still 60% of that litigation time-wise anyway, to happen. They knew all this, and they voted to continue the litigation and continue Finney as the point man with other people helping them. They saw the bills coming in, and the other problem is there's no finding anywhere in the record where the court decides what exactly is spiraling out of control, what is that damage item versus what they would have paid anyway, other than his assumption that the lawsuit would have cost $350,000. There was no discussion on the record of what bills we would have spent anyway and how much that was. And so that's just a complete guess by the court as to what the damages are. There's no evidence to support it. So that's the other problem. But the biggest thing is these guys knew what they were doing. He says several times they were sophisticated, intelligent men. And they found out what happened with this letter, and they chose to go ahead. They weren't being bullied. They knew what they did. They're going to take their chances. So that is, in my opinion, voids that whole argument that we got hoodwinked because we didn't know one case was stronger than the other. And what's interesting is, like Mr. Line said, the weaker case was the one that avoided summary judgment that they ended up settling for $220,000. And who knows how much more could have been settled for if the attorney would have taken some depositions and did a little discovery, which he didn't do before he settled. So anyway.
Okay, well, we appreciate your argument, counsel.
All right, thank you.
May it please the court. Good morning. My name is Grant Watercutty. I represent the Arizona Biltmore Condo Association. Your Honors, this appeal is essentially an attempt to relitigate nearly 2 weeks of trial testimony in which Mr. Finney sought unsuccessfully to convince the court the 2013 action and the 2010 action were one and the same. He attempted to convince the court that a contract that was entered into by sophisticated individuals in 2011 referencing a specific action by name, by case number, is the same as an action that was filed 2 years later against different parties that was not contemplated at the time of that contract, that was not written into that contract, and that pertained in no way, shape, or form to that contract. Mr. Finney is now attempting to say that the safe harbor provision applies to that 2013 action, when in fact there is no evidence at the time that they entered into that contract that Mr. Finney told anybody that not only does this contract mean you are required to litigate the 2010 action for the benefit of my wholly owned company, it means that if something happens to that 2010 action, you're required to litigate that same set of facts.
But what about your colleague's argument that's what the contract said?
Well, respectfully, Your Honor, if you look at Exhibit 5 in the record, which is the contract doesn't say that in any way, shape, or form. It says, and the court found in its ruling, I believe it's on page 17, that the only obligation the association has pursuant to that contract is to vigorously litigate the 2010 action. That is the only obligation the association had. There's nothing written into that contract.
Isn't there, though, the sublease agreement?
Correct. In the event the
So isn't that what they're talking about?
That is what they're talking about. And in the event the 2010 action was successful, then the association was required to provide that sublease to Mr. Finney's group at, I believe it was $100 per year, that he would have for the next 60 years. But again, only in the event the 2010 action against the hotel was successful. SRP is not mentioned in that contract. No other attorneys are mentioned in that contract. No future lawsuits are mentioned in that contract. Pursuant to that contract, if it had been successful, yes, Mr. Finney would have been entitled to that sublease. He would have had the benefit of that provision for the next 60 plus years. And according to Mr. Finney, he would have made $18 million as a consequence. Now, we argued at the trial court level that that in and of itself was a breach of fiduciary duty. Mr. Finney attempting to gain $18 million in exchange for $500,000 of bankruptcy fees.
So let's say that we have Mr. Finney who has this subjective belief that I'm pushing forward on the 2013 lawsuit, and I'm doing so because I'm getting paid at the end. Okay. Do we consider that's not possible because Mr. Finney didn't even pay the fees under the 2010? I guess what I'm asking is the subjective thought, if erroneous, of a director, does that need to be disclosed under the interested director provision? If it's just flat wrong. He wasn't going to get the money because he didn't pay the attorney's fees, which was his part of the deal. So any things he might have thought are commentary and not informative.
Well, I would say if that was his subjective belief that he was going to benefit from something he was inducing the association to do based upon negligent misrepresentations, as the trial court found, then yes, he would be obligated to disclose that subjective belief, unless, if I'm understanding you correctly, he believed, well, no, even though I would want to get that, it's not possible because I've already breached my other obligations and not funded the bankruptcy. I guess that would change his subjective belief, but.
Right, no. I am accepting that Mr. Finney, as the court found, believed that he would ultimately be paid at the end of the 2013 lawsuit. But my question, and then that needed to be disclosed. So my question is, well, let's say Mr. Finney had a subjective interpretation that the world is flat, or something that was just flat wrong. Do we have that same disclosure requirement, even though the point is not meaningful?
Well, I think if the ultimate conclusion, his subjective belief that the world was flat would somehow end up transferring $18 million of the association's money into his pocket, then yes, he would have to disclose his subjective belief that the earth was flat. And I'm not trying to make light of your question. I'm just not sure I understand it.
No. You're saying he thinks it's flat. He's a director. It is his obligation to share information, not for us to assess the quality or of that information or import. It's just what is in his mind. He owes it to others, even if it's flat wrong.
But I think so long as whatever information he believes, wrong or right, in his mind transfers the interest of the association into his bank account, then yes, he should be obligated to disclose that, even if he's wrong.
To the extent he wants to avail himself of the safe harbor.
Correct. Yes, Your Honor.
What about this southern attorney fee award? So I guess I have one question. Are fees included that shouldn't be in the court's award?
No, Your Honor, and I'll give you my explanation as to why I believe that to be the case. If Your Honor considers that at the time we were making this argument, it was the association's contention, and we're not cross-appealing, but it was our intention to seek damages for the 2010 lawsuit, as well as all the fees incurred during the 2013 lawsuit. We presented that information to the court, and it was broken down by our expert, and the court accepted the expert's report. What the court did in making its ruling is he went ahead and subtracted the $350,000 from the total amount, and that $350,000 was premised upon what CIM estimated the association would be required to pay at the outset of the 2013 lawsuit, and it was further supported by a $4,000 special assessment that was made on each villa owner that totaled close to the $350,000 that CIM estimated. The court reasoned that the association's board, and this is a finding of fact which is reviewed for clear error, whereas findings of law are reviewed de novo, he found that the board would have entered that action and would have spent up to $350,000. So he took the total amount, which was $1,049,000, subtracted the $350,000, and then subtracted the $220,000 that was received for settlement purposes. And if I could point, Your Honors, to the case law that's cited in our brief, for purposes of damages, the trial court's ruling is not to be overturned unless there is clear error, and if there is any reasonable basis upon which the judge could base that damages finding, that is to be upheld upon appeal.
But the court, we agree that the court said no damages for litigation of the northern lots. We can agree on that, right?
We can agree. Judge Broadman said that, yes.
Okay. And then we have the court's calculation of damages, in which it begins with a figure and then it subtracts settlement. Well, if there's no express subtraction of a northern attorney fee, why isn't that plain error?
Well, Judge Broadman reached his conclusion as the ultimate figure based upon how it's laid out in his order, and I would submit to Your Honor that it would be virtually impossible to go through the bills of a 4-year period of litigation pertaining to both northern and southern parking spaces and delineate on a line item basis which item refers to the northern and which item refers to the southern.
What about on a subject matter basis? I'm not asking a line item basis.
You can to an extent, I believe, but at the same point, things like appearing for hearings, traveling to and from depositions, making a phone call with various attorneys, those are going to be advancing the case on all fronts in most situations. There could be very specific motions, specifically the summary judgment motion as to the northern
Isn't that
spaces.
true? Isn't this true with almost any damage calculation? We have to let the trial court make a reasonable effort to apportion liability or apportion damages between the competing claims. I'm not saying it's easy, and that's probably why I'm here instead of in trial court, but isn't that what we do all the time?
I can't speak to what you do all the time, Your Honor.
I mean,
meaning
the judicial system.
It certainly could have been broken down more at the trial court level. The issue is whether or not
I mean, and it doesn't have to get it perfect. You might say, all right, we're going to divide that in half because it seemed like it's 50-50 after the date on which to start pursuing the northern litigation. And then we'd be coming back to review that on an abuse of discretion standard. But it sounds to me like, from the record I looked at, that there was, he said no northern, and there's clearly northern included in the attorney's fees.
That is correct, Your Honor. If you look, though, at our brief, and I don't recall the specific numbers off the top of my head or the exact dates, but the dispute over the northern spaces came to a close much sooner than the dispute over the southern spaces.
Right, so it might be a small number that needs to be backed out of there, but
Well, it could be, but the fees incurred from the date that the northern spaces was dismissed to the date the lawsuit resolved were actually greater than the amount that Judge Broadman actually ordered. So even if you accept that as true and he adopted that particular finding, the ultimate result would have been larger than it currently is. And so, and again, we're not cross-appealing, but the ultimate figure that he came out with is less than I think you would have even in the event that you just cut off the fees from the moment the northern spaces aspect of that case was dismissed.
Well, but it's not for us to do. I mean, this is stuff that should have happened, I guess, presumably in the trial court. But I mean, I don't think you're arguing that if things aren't, if time isn't parsed with a surgical knife, then you got to give us everything. I mean, doesn't that sort of turn the incentive on its head? And maybe we should say, unless you can show that your work as an attorney was for a compensable project, you're not entitled to it. I mean, is that a reasonable sort of alternative to your argument?
I certainly understand the court's point. I think what I would say at this point is that damages awards are to be reviewed on an abuse of discretion basis. And if there's a reasonable basis to uphold it, then that is what is supposed to happen. Now, whether you, and this is the law, whether the appellate court would go back and do things differently, if there is any reasonable basis to support the decision of the trial court, that is to be enforced. And in this particular case, what Judge Broadman found is that there is a reasonable basis to believe the association, whether for the northern spaces or the southern spaces, was willing to pay $350,000 to fund that litigation. and as the consequence of the negligent misrepresentation and breach of fiduciary duty by Mr. Finney to induce them to go beyond that, anything beyond the $350 and the $220 that they received in settlement is a reasonable award of damages because of his conduct.
So, that's your argument in the reply brief, or in the your answering brief. Okay, so if we have, let's say we're persuaded that the Northern Lot litigation was lumped in when it shouldn't. Is there anything in the record from the trial court? Your colleague said that I don't know how, but there's no like attorney fees, invoices, and it's just an expert witness reading that. That seems, I don't know. It doesn't sound necessarily right. What is the record below, and what is your thought on what we should do, assuming and you know, certainly haven't gone either way, but assuming we were persuaded on that point?
Well, I don't believe that's entirely accurate as it relates to the record. Board member Chuck Larson is one of the individuals who testified, and I can't point it to you in the trial transcripts off the top of my head, but if you look at his testimony, he discussed directly the amount of fees that the association incurred as it relates to the 2013 lawsuit and the other actions. So it wasn't simply the testimony of our expert Dwight Duncan, who also provided that information, but it was also the testimony of Mr. Larson. And when it came to the time to submit the bills to the court, and this is in the record, Judge Broadman stated something to the effect of, I don't really need those. We have the summaries. I'd rather not receive 3 bankers' boxes full of legal invoices over the course of the last 4 years, which is what they were. I mean, the amount of paper records were astounding. And so in the interest of judicial economy, we based it upon the testimony of Mr. Larson and the testimony of Mr. Duncan.
So did anyone move to admit?
I did, Your Honor. And
it was denied?
It wasn't denied. The response was, I don't think I need that. And I believe that's a direct quote, and if I'm misquoting it, I apologize.
But you were submitting the entirety of the records because at the time you were pursuing claims based upon both the Northern and Southern.
Correct.
So you didn't think you had occasion to parse it out.
Correct. That was our argument at the time, Your Honor. And we submitted all of the legal invoices from CIM for the entirety of the 2013 lawsuit. If I could jump ahead just briefly to a couple of the other arguments that were raised. Let me respond to Mr. Finney's argument that the Conlon Group was in fact the party that was not in breach of contract and is entitled to damages. The fundamental fact there, Your Honor, is that the court found as a finding of fact that the association met all of its obligations pursuant to the Conlon Group contract by vigorously litigating the 2010 action to a close. And so there cannot be any breach of contract action against the association unless you accept the fact that the 2013 lawsuit was an extension of the 2010 lawsuit, which for all the reasons I've previously discussed is simply not the case. The other thing I wanted to address is the argument of attorney's fees, which was raised by Mr. Finney, that he was entitled to his attorney's fees as the prevailing party on the basis that multiple causes of action that the association had against him were summarily dismissed. The association in this case brought suit against Mr. Finney because they knew he was going to be bringing suit against them, and they wanted to get this over with as quickly as possible. He filed his counterclaim, which he had threatened on multiple times, as is seen in the record, and ultimately the association ended up with a judgment against him and his wholly owned company for greater than $500,000. They also ended up with a fee award. On multiple occasions, and this is contained within the independent record 174, which is the court's finding on attorney's fees, the association made offers to Mr. Finney to put hundreds of thousands of dollars in his pocket if he would simply go away. He didn't accept those offers and ultimately ended up with over a $500,000 judgment against him. Clearly, we were the prevailing party in this case. And jumping back to another point that you raised with Mr. Finney's attorneys, as it relates to the failure to disclose certain aspects of the 2013 lawsuit. I don't have much time here, so I won't go into the actual content, but if your honors look at exhibits 83 and 84 after we're done here, that is the March 2013 letter from CIM to Mr. Finney, and it is the subsequent update he sent to the board and the villa owners after receiving that letter and not providing it to the board. And if you look at the content of those two, Mr. Finney's picture of the lawsuit that he provided to everyone else is quite different than the picture that was painted to him by the attorneys from CIM. Respectfully, I don't have anything further unless you have any additional questions for me.
Well, thank you, counsel.
Thank
We appreciate all of the arguments today, and we'll take it under advisement. With that, we are adjourned.